This, we are going to see the judiciary and the independence of judiciary and the importance of judiciary. Now, what do you mean by judiciary? A judiciary is an important organ of the government. The Supreme Court of India is in fact one of the very powerful courts in India, all over the world also. Right from 1950, the judiciary has played an important role in interpreting and in protecting the constitution. So since the constitution was followed from 1950 January 26 that we are celebrating it as a Republic Day, from that period itself, Supreme Court or judiciary, whatever, has played an important role in interpreting and protecting the constitution. The principal role of judiciary is to protect rule of law and ensure supremacy of law. It safeguards rights of the individual, settles disputes in accordance with the law, and ensures that democracy does not give way to individual or group dictatorships. In order to be able to do all this, it is necessary that judiciary is an independent of any political pressures. So regarding the safeguards of the individual, the judiciary play an important role. It settles and disputes according to the law, so that no individual or group may not violate the laws and regulations. In order to able to be do all this, it is necessary that the judiciary is an important of independent of any political pressures. So independence of judiciary. Independence of judiciary means that the other organs of the government, like the executive and the legislature, must not restrain the functioning of judiciary in such a way that it is unable to do justice. That is, no other organs of government should not induce the judiciary to unable to do the justice. It is a separate one. The other organs of the government should not interfere with the decision of the judiciary. Judges must be able to perform their functions without fear or favor. So, independence of judiciary does not imply arbitrariness or absence of accountability. Judiciary is a part of democratic political structure of the country. It is therefore accountable to the constitution, to the democratic traditions, and to the people of the country. How can the independence of judiciary be provided and protected? The Indian constitution has ensured the independence of judiciary through a number of measures. So to protect independence of judiciary, our constitution will give the number of measures. The legislature should not involve in the process of appointment of judges. Thus, it was believed that party politics would not play a role in process of appointments. In order to be appointed as a judge, a person must have experience as a lawyer or must be well versed in law. Political opinions of the person or his or her political loyalty should not be the criteria for appointments to judiciary. The judges have a fixed tenure. They hold office till reaching the age of retirement. Only in exceptional cases, judges may be removed, but otherwise they have the security of tenure. Security of tenure ensures that judges could function without fear and favor. The Constitution prescribes a very difficult procedure for the removal of judges. The Constitution makers believe that a difficult procedure of removal would provide security of office to the members of judiciary. The judiciary is not financially dependent on either the executive or legislature. It is a separate organ of the government. The Constitution provides that the salaries and allowances of the judges are not subjected to the approval of legislature. The actions and decisions of the judges are immune from personal criticism. The judiciary has the power to penalize those who are found of guilty of contempt of court. This authority of the court is seen an effective protection to the judges from unfair criticism. So this ability to penalize those who are guilty of contempt of court is the main power which protects the judges from unfair criticism. So regarding the composition, Art 124 of the Constitution provides that there shall be Supreme Court of India which consisting of Chief Justice and 7 judges. Further, it says Parliament by law may increase the number of judges. The Supreme Court of present comprises 25 judges, including the Chief Justice of India. Includes the Supreme Court of India. Now it is having 25 judges, including the Chief Justice of India. Art 124 of the Constitution said that Supreme Court of India can have Chief Justice and 7 judges. Next one is appointment of judges. Art 124(2) provides that judges of Supreme Court shall be appointed by the President of India after consultation with the judges of the Supreme Court and High Courts. In case of Chief Justice appointment, the President may not consult other judges. After 1993 Supreme Court decision, it is now convention that senior most judge of Supreme Court becomes Chief Justice of India. So now we are going to see about the qualification for the appointment of judges. Act 123 provides following qualification. That is, he must be a citizen of India. First qualification to appoint as a judges is he must be a citizen of India. Then he has been judge of High Court for at least 5 years continuously, or he has been an advocate of High Court for at least 10 years continuously, or he is in the opinion of the President of India as a distinguished citizen. So these are the major qualifications to appoint as a judge. The first one is he must be a citizen of India, or he can practice as a judge of High Court for at least 5 years continuously, or he has been an advocate of High Court for at least more than 10 years, or he should be in the opinion of President of India as a distinguished jurist. Then tenure. So tenure is nothing but the time period of to act as a judge. A person continues as a judge of the Supreme Court during his good behavior until he attains the age of 65 years, whichever is removed. So how the judges is removed? So under Article 124, a Supreme Court judge can be removed on the grounds of misbehavior or incapacity only. It was very difficult to remove a judge from his position. There are several rules and regulations that are needed to remove the judge from his position. So under Article 124, a Supreme Court judge can be removed only on the grounds of misbehavior or incapacity. If he is misbehaving or he is incapable to do the work, he can be removed. The procedure to remove a judge is called as impeachment. Any house can initiate impeachment motion, and if it is passed by 2/3 of majority in each house, the judge will be removed. Then immunities. The actions and decisions of the judges in their official capacity are immune from criticism. Under Article 121, conduct of Supreme Court judge cannot be questioned in Parliament. So regarding the appointment of judges, the appointment of judges has never been free from political controversy. It is a part of political process. It makes a difference who serves in the Supreme Court and High Court. A difference in how the Constitution is interpreted. Removal of judges. The removal of judges of the Supreme Court and the High Court is also extremely difficult. A judge of the Supreme Court or High Court can be removed on the ground of proven misbehavior or incapacity. So this is the main thing regarding the judiciary and the independent of judiciary and the appointment of judges and removal of judges.